Morning, Alan. You okay?
I'm well, John. Are you?
Good, thanks. It's snowing here, but snowing with you?
Yes, it's snowing and it's all over the country today, I think, John.
It's all over the country. But we are talking about a much warmer subject this morning, Alan. We are talking about the Employment Rights Bill and, in particular, the some of the consultations that are taking place currently and that are really impactful in this area. So we did a webinar last week, well received by our client base. And we talked about the Employment Rights Bill, what the Employment Rights Bill contains, and some of those consultations. If we were to speak at length on the Employment Rights Bill now, we could speak for 3 or 4 hours. It's a massive piece of legislation, but I think we might lose the listener. So we're going to speak for 15 to 20 minutes on some of the more impactful elements of the consultations. There are 4 consultations ongoing at present. And you're going to pose some questions to begin with in relation to some of those questions, and we're going to talk about those.
Absolutely, John. So we're going to focus on 2 consultation papers. One is the consultation about collective redundancy and fire and rehire. I'll come on to explain about those in a minute. And the other is the application of the 0 hours contracts to agency workers. We know the government are going to make some changes to 0 hours contracts, make it more difficult really to have them, not ban them, but also to consider whether those provisions will apply to agency workers. They haven't decided that and they're consulting about it. So first of all, the collective consultation. So let's just remind us what collective consultation is. So it usually crops up with redundancy. It can also crop up with a change of terms and conditions, but let's focus on redundancy. If an employer is going to make at least 20 people redundant in a 90-day period or less, they have to carry out collective consultation with either trade unions reps or elected employee reps. And they have to do that for a minimum of 30 days before the first dismissal can take effect. If they're going to make more than 99 people redundant in a 90-day period or less, that period of consultation is a minimum of 45 days before the first dismissal can take effect. Now, what we're looking at in the consultation paper is increasing what we call the protective award. So at the moment, if an employer doesn't comply with the collective consultation requirements, they can be made to pay up to 90 days pay per employee affected. Now, this isn't compensation. It's almost like a penalty. And so, yeah, it's a penalty. And we've seen huge cases. We've seen, you might remember when Woolworths closed down and they hadn't done it properly, for example, and the government had to pick up the tab. Now, what the consultation is talking about is doubling this 90-day period of compensation, or equivalent to 90 days pay, to up to 180 days. It's asking the question, should we double it to 180 days? And it also asks a different question of, should we remove the cap entirely and let the tribunal judges decide exactly how much compensation they're going to award? So if we focus on that first of all, and have a look at some of the questions, you and I can discuss these now and see what we feel about this. So let's just assume that we're going to remove it altogether. Let's look at the most draconian situation. So what the question in the consultation paper, and by the way, these consultations are to be finished by the 2nd of December.
It's
the
very
19th
quick.
of November. Yeah, it's right too quick, John. It's the 19th of November today. We've got a couple of weeks or so before this is finished. So the question is, what do you consider to be the impacts on employers of removing the cap on the protective award? So that we're looking at the impact on employers, not employees in that question. Clearly, the risk of getting it wrong is going to be huge. It's double the amount of compensation that the penalty that's going to be paid out, and that's massive for business. I think it would have a massive impact. What do you think, John?
I agree, Alan. I mean, I think it depends whether the government, and we talked about this in our first podcast, is almost has to make a binary choice between, sometimes you're going to protect the rights of the worker, or how far you go and protect the rights of the worker, and how much you're going to go for growth. And, there are some businesses now saying, well, we need to make redundancies because of what you put in the budget. And at the same time, you have the Employment Rights Bill coming in, which is saying we might be either doubling the amount of the protective awards and or removing the cap entirely. And it is potentially draconian. And if you couple that with the elimination of small point, it's not front page news, maybe buried in page 17 of the papers, of the definition of establishment in the Employment Rights Bill, where It used to be that you had to make it redundancies from one establishment, 20 or more. Now the establishment is the entire business and including a number of sites. So it will increase the risks for businesses if this is introduced, and it will probably double the cost of protective awards.
Yeah, and I had experience of exactly this several years ago. I acted for a large retail company. We closed 104 branches, and there were between 4 and 6 people employed at each branch, and we made more than 500 redundancies. But because we treated each branch as a separate establishment,
That's a good point.
we didn't need to do what would have been at the time. It was 90-day consultation at that time for those numbers. Of course, that means paying the salary bill for another 90 days before you can dismiss. And then when you dismiss, you pay notice pay on top of that. So it was a very expensive exercise. Now, we wouldn't get away with that now, because when this change comes in, we'd have to tot up, well, there's 2 at this branch, 5 at that branch. As soon as it gets more than 20, we're into collective. And yeah, I think it's tough. This is a very tough piece of legislation, and it's going to make it difficult for business, difficult for growth. And as you say, there are a lot of redundancies happening now because of the national insurance rise as well, in particular. So, I think it's a tough measure. One of the questions is, do you think that doubling the cap will incentivize employers to comply with their obligations to collectively consult? Has to be yes, John, doesn't it?
I'm not sure, Alan. I mean, I think that most of the time you're forced into this as an employer, and no one wants to make redundancies, and you do it for financial reasons. And so I think what it might do is see almost a rolling redundancy program by some employers, because they're not going to want to do mass redundancy, so they're always going to be looking to trim the fat, as it were. And there's going to be more obligations on HR people. So some of what we talked about in the ERB in our webinar last week was putting more burden on HR people to constantly monitor resources, etc. Because I think a lot of the time, and when employers are forced into this position, they don't have a choice. They're being forced to do it because the CFO or the FD is saying you need to cut costs, or the bank is saying you need to cut costs. So I wonder how much it will incentivize employers to comply. I think this will just be a doubling of cost.
Yeah, and here's an interesting question. Some of our viewers might be thinking, well, what about the government picking up this award if the company goes into insolvency? I think the plan, I've not read the finer print, but I think the plan is not to apply this increase to claims against the National Insurance Fund. So it's not going to penalise the country any more than it does already, because that is something to bear in mind. If the company goes insolvent, it is the country that has to pick up these protective awards at the current levels. And we've seen lots of that throughout history, which cost millions. And that's the taxpayer picking it up, John. So, interesting point.
So you also do a lot of work in interim relief cases, Alan. You're one of the main solicitors in the country that has done work on interim relief and whistleblowing cases. If you can briefly explain how you get an interim relief application is in whistleblowing cases, and then how they're thinking of extending interim relief in relation to other areas in the Employment Rights Bill.
Yeah, John, for sure. Thanks. So, in a whistleblowing case, if an employer dismisses an employee for blowing the whistle, so when we're talking about whistleblowing, I mean somebody's made a complaint about something they believe the employer has done wrong, which they think is a criminal offence or a breach of a legal obligation, and there's some public interest in them raising that with the employer. So it has to be some. So an easy example is employers paying people in cash. It's not going through the tax system, and the employee complains about that. There's a public interest element. If they make a complaint about that, and then they believe they're dismissed because they made that whistleblowing complaint, they can claim automatically unfair dismissal in the tribunal, and they fill in an employment tribunal claim form in the usual way for unfair dismissal, and eventually 18 to 20 months to 2 years later, it gets listed for a hearing. Yeah, those are the delays we've got in the tribunal at the moment. With interim relief, which is a special kind of relief that's available for whistleblowing and also for some dismissals for trade union activities only, if the employee within 7 days after being dismissed makes an application to an employment tribunal seeking interim relief, there will be a quick hearing arranged. The last one I did, it was arranged within 2.5 to 3 weeks after the dismissal. And basically, there weren't many papers. You don't have to have many papers, but there's an argument before a judge. It might be 2 to 3 hours at most. So there's not a lot of time to put lots of information for the judge. And the judge will be looking to see whether they believe that the claimant has a pretty good chance of winning their final case, their automatically unfair dismissal case. And pretty good chance is quite high bar. I would say it's about 80% chance. If they believe that the claimant has a pretty good chance of winning their case, they will tell the employer to take the claimant back onto the books, back onto the payroll. Yeah. Massive. And the employer will have to pay that employee until the final hearing, maybe 20 months, 2 years later. And here's the real stinger, if the employee loses that claim at the final hearing, they don't have to pay any of that salary back that they've had in the meantime. The employer might say, I don't want them back, still got to pay them, even though they're not working. So this is a huge remedy. Now, there's a proposal in the consultation. Do we introduce this interim relief action? Do we introduce the availability of it to those who feel that the employer has not complied with the collective consultation obligations? Now, just to recap, in whistleblowing, it's very complex and it's very difficult for a claimant to win an interim relief order because there's all sorts of things that go into whistleblowing claim. What is whistleblowing? What is not whistleblowing? It's very, very technical, a lot of case law, and it's very easy for a judge to say, I can't make my mind up on this until I've heard evidence at a final hearing, and I'm not hearing evidence in this 2-hour hearing. So I'm going to say, I cannot say there's a pretty good chance you're going to win. But collective consultation is much simpler.
Easy to trip up.
Yeah, were the union, was there consultation with union reps? Was there consultation with employee reps? Were there enough meetings held? Was enough information given? And it may be, so if they do introduce this, I think it would be a lot easier to get a decision in favour of a claimant for interim relief. And it's huge, the costs that will have to be paid out, the money.
Well, I put my head in my hands as you were speaking, because this does strike me. It's a very powerful remedy, I agree. For claimants, it's basically the nuclear option, isn't it? It's probably the single most powerful remedy in all of employment law, because if you've effectively been dismissed or suffered a detriment, and you are going to the tribunal to saying, I'm going to compel you as the employer to take me back onto the books. And the lapse in time, as you know, between an interim relief hearing and the final hearing can be 6, 9, 18 months. So the employer has to employ the employee for all of that time. It's massive. The reason why I put my head in my hands when you were speaking is I just can't see how it can work in this scenario with protective orders, because by definition, or protective orders or redundancy consultation, because by definition, the employer is on its uppers at that time, isn't it? That's why it's making redundancies. And so if there was a technical breach, which would be relatively, I think, easier to prove, I agree, than the standard whistleblowing case, the implications of a mass group of employees being compelled to be employed by that employer until the final hearing, that's the corollary of this.
Yeah.
It's going to add, I mean, it'll put employers out of business. So you'll see, if they introduce this, you'll see employers losing interim relief hearings effectively in redundancy cases, and announcing that they're going to go into administration the next day, because they won't be able to take back onto the books the 20, 40, 60, 100 employees and employ them for another year. Do you agree?
Exactly.
I mean, that's the corollary of this.
Absolutely agree. The only reason to make redundancies is that we don't need as many people. We could perhaps replace with machines and things, but usually it is we can't afford. We need to make big cost cuts.
Yeah.
We can't afford the wages. So if I've got 30, 40 people and I can't afford to pay them now, I certainly can't afford to pay them for another 20 months until they get to a hearing. So where is the sense in this proposal? I can't see it, John.
No, I mean, I hope. I mean, we would urge the listeners to write in and say that, of all of the suggestions that I have seen in these consultation papers, I think that this is possibly the most bonkers that I have seen. I mean, I haven't read absolutely all of it, but I mean, when you're just talking there, the corollary of this coming into effect will be to put businesses out of business, and that's in no one's interest, going to increase the cost of the public purse, unemployment benefits and the rest. I want to just talk briefly for the last 4 or 5 minutes on the 0 hours proposals. Do you just want to remind me what those hours in terms of agency workers, and then a lot of my client base is in relation to some of the larger agency suppliers in the country. So if you pose the question, remind me what it says, I will speak on that.
Yeah, let's have a look. So they're looking, if you remember, for agency workers, after a certain period of carrying out the agency, they're looking at them being offered guaranteed hours.
Yeah.
Okay. And that's really interesting because, I mean, it's usually the agency that's, if anybody, is employing the individual. It's not the end user in most cases. But if the end user has to offer sort of guarantee, is it the end user who has to offer guaranteed hours, or is it the agency? They're not clear about that, government. If it is the end user, that means by definition, the end user is entering into a contract of employment with the agent. And that's a fundamental shift in what we've seen in agency over the years. Do you just want to comment on that point at the moment, John, first of all? That change for them, who employs
Yeah, I mean,
the
I agree.
agent?
I mean, I would definitely say on behalf of most of my clients that this, again, would be pretty damaging to the British economy because we have the most flexible economy in Europe. It's the second most flexible in the Western world after the United States. More agency workers get up and go to work here in the UK than in the rest of Europe combined this morning. And we're very good at getting people into work in this country, particularly younger workers into work. We're very good at flexible working models. And I think we tamper with that at our peril, actually. And so the whole concept of agency work is it's at will employment. An agency is supplying a worker often on a spot basis to an end user. And the end user doesn't have, by definition, the guaranteed hours, or else it wouldn't engage with the agency and pay a margin to the agency for the supply of that worker. Now, there are arrangements where sometimes agency workers are supplied over a longer period of time, and do you guarantee that? But I just think that it's some of that can be dealt with in the agency workers regulations, which I thought the previous government would repeal and haven't been repealed. And I don't think this government will repeal them now.
Well,
go on.
They are going to bring in guaranteed hours.
Yes.
So the question is, should the guaranteed hours, this is in conversation, be offered by the employment agency or by the end hirer? That's one of the questions of consultation. What's your view, John?
I mean, I think it would have to be by the employment agency, because I agree with you, by the end hirer, it would destroy the model and it would eliminate employment agencies if that were to be the position. I just wonder whether in practice there'll be some kind of local opt-outs in terms of what actually happens, because most agency workers want the flexibility that agency work means, and the increased hourly rate on a per diem basis for that work. So, I'm old enough to remember when there was no right to statutory holiday pay in this country, and the working time regs came in, and they thought that would eliminate agency working in this country. And actually, the industry absorbed that and dealt with it pretty well. So I'm relatively confident that they will be able to absorb this change as well. But I just hope that there isn't too much tinkering with increasing fixed costs for employers.
Yeah, and there's another interesting one. If they do decide to legislate so that it's the hirer that has to offer the guaranteed hours, that means, as I've said, the agency worker becomes employed by the hirer, and therefore, well, if they're no longer on the agency's books, is there a transfer fee payable by the hirer? As is usual, if you take somebody on permanently, you pay a fee for that.
It's a very good point.
Found it. So the question is, as an alternative to paying a transfer fee, should the end hirer take up an extended period of hire? So here's the question: should end hirers be required to pay a transfer fee or use an extended hire period if they're required to offer guaranteed hours to an agency worker? Really difficult question.
Complex stuff. I mean, I'm sure they won't want to incur the upfront costs of transfer fees, because that's a flat cost on them. So then they're compelled for an extended period to take on the agency worker, but they might not have the guaranteed work. So you're back to where we started at the beginning, which is what happens if you don't have that guaranteed work partway through that hire period for the worker. So there are lots of complex and knotty issues in these consultations, and I know that some of the organisations where members of APSCO and the REC are going to be lobbying very hard in relation to this to try to get the government to leave well enough alone. We'll see whether they do or not.
If I may, John, just one other thing which is very interesting. So there's another provision that the government are going to bring in is about short notice. If a shift is cancelled at short notice to a 0 hours worker, they'll be entitled to some sort of compensation. So let's think how that applies to an agency worker. So should the agency be responsible for paying any short notice cancellation or a curtailment payment of a shift to an agency worker when the agency has no control over deciding what resources are required?
But that's a very good point. But the agency, as you said at the beginning, is responsible for the pay on a PAYE basis of the agency worker, but it is reacting to a decision that will be made by the hirer. I think one thing that will change in relation to this, there'll be really interesting commercial style review of commercial agreements, because that is the sort of issue that we dealt with by way of warranties and indemnities in the main commercial agreements, a technical point between the hirer and the agency worker as to who actually picks up the tab, who bears the risk, the commercial risk in relation to the scenario that you're talking about. I suspect you're right that the obligation to pay, because it has to be the case, will be on the agency because they are the employer on a PAYE basis. But who ultimately picks up the tab will be defined in commercial agreements between the agency and the end user. And some of these are very large commercial agreements. Some of the largest employers in the country are very hungry users of agency workers. Some of the biggest retailers in the country, you're very entrenched in the logistics space.
Yeah.
So, and you might have Tesco's or Sainsbury's saying, well, you can only supply to us as an agency if you agree to pick up this tab. So it might become a precondition of supply that agencies bear this cost.
Yeah.
So
I just think,
so we'll see.
Doesn't that increase the cost of using agency workers as a whole? Is much more involved. I can only see the cost of that going up.
Most of this is inflationary, I have to say. Yeah. I mean, there's a danger because it's snowing outside that we sound like two old Grinches. But most of this is inflationary because you're right to alert the listener to these risks, and at some point the costs are going to be passed on. Most of the listeners will know that as a result that your Ubers cost more than they did 2 or 3 years ago. Why is that? It's because Uber lost an employment status case and they now have to pay holiday pay and other employment rights to Uber drivers. Some will say that's absolutely the right thing, but the result of that is that the differential in Uber being cheap and black cabs, for example, in London being expensive, it's much more limited than it was. So it's an inflationary cost. And the inflationary cost has been created by an employment law risk. And that's a lot of what we will see here. Thank you, Alan.
So, John, we've dealt just with a few points there, and we've been able to talk for quite a long time about just those few points. There's an awful lot in this consultation.
There's an awful lot. We could speak for hours. This is tip of the iceberg stuff, isn't it? I mean, maybe we should do a few of these just to unpack some of the knottier issues around the consultations on the Employment Rights Bill.
Okay, great. Thanks, John.
See you soon. Take care.